A pro se litigant wrote this: Judge Matt Bertani has it figured out. Judges need to stop ignoring or disregarding what pro se litigants say in paper or in court. Stop deferring to opposing counsel as if he or she is infallible, and start supporting all rulings with applicable law. These orders that do not explain why they are issued are tantamount to aiding and abetting opposing counsel's cheating in way too many circumstances.
The pro se's concern is legitimate. You know, in certain circumstances, the judge is required to give an explanation for his or her judgment. And in certain circumstances, the litigant can ask the court to give an explanation for its ruling in certain circumstances. These are a due process right. And that's what we're going to talk about today. When the judge is required to give a reason, and when the litigant can ask the court to give a reason. So let's get started.
And we are going to look at court orders and judgments that explicitly require a judge to give a formal explanation, findings of fact, or conclusions of law. And this will include the federal court, we'll look at civil litigation, the federal court criminal litigation, the federal court appellate procedures, and the trial and lower courts civil and criminal litigation. So let's start with the federal court civil litigation. And here we'll be referencing Federal Rules of Civil Procedure 52, findings and conclusions by the court, judgment on partial findings. Now, concerning judgments in a non-jury bench trial. In a bench trial is where the judge and the judge alone hears the case without a jury. Under Federal Rules of Civil Procedure 52A1, the judge acts as the trier of fact and must explicitly find the facts, specially, and state its conclusions of law separately. Whereas in a jury trial, the jury is the sole finder of facts. The Seventh Amendment designates the jury as the ultimate trier of facts. Interlocutory injunctions. And of course, that is where the judge issues a temporary order of some kind until the matter has been resolved or has gone to trial or final judgment is made. When granting or refusing a temporary restraining order or preliminary injunction, Federal Rules of Civil Procedure 52A2 mandates that the judge state the findings and conclusions that support the action. The summary judgment. Under Federal Rules of Civil Procedure 56A, the court must state on the record the reasons for granting or denying a summary judgment motion. Evidentiary rulings or contempt. Orders that significantly impact trial rights or impose punitive measures like contempt of court require a clear explanation. So you see the due process at work here. Remember, the due process has established that the government cannot take away a person's life, liberty, or property without a hearing or procedural fairness. Class action settlements. Under Federal Rules of Civil Procedure 23E2, a court may only approve a class action settlement, voluntary dismissal, or compromise after a hearing and upon finding and explaining that it is fair, reasonable, and adequate. Rule 11 Sanctions. If a judge imposes sanctions on an attorney or party for frivolous filings, Federal Rule of Civil Procedure 11C6 states that the order must describe the sanctioned conduct and explain the basis for the sanction. Because again, you're protecting the person's life, liberty, and property. Conditional new trial rulings. If a judge grants a renewed motion for judgment as a matter of law, Federal Rules of Civil Procedure 50C1 requires the court to state the grounds for conditionally granting or denying a concurrent motion for a new trial. So before we go to the federal court criminal litigation, let me back up a little bit here and revisit the motion for summary judgment. And I want to also include the 12B motion to dismiss. The judge is not required to state formal findings of fact or conclusions. Remember, the judge is not weighing evidence to decide the truth, both in the motion for summary judgment and the motion to dismiss. Here's what the judge is doing. The judge is attempting to determine whether the pleadings are legally sufficient or if there are undisputed material facts supported by evidence in the record sufficient for the plaintiff to overcome or prevail over the defendant's motion. In a nutshell, the complaint must state a viable claim, and that is what the judge is doing, okay? So let's look at the federal court criminal litigation. And I want to start with some statutes that we'll be referencing for this area of discussion. Of course, the Federal Rules of Criminal Procedure, and you'll find that discussion in the 18 United States Codes section. And this 18 USC edu/rule/FRCRMP/ is the link that you can reference. Then there's Rule 12, pleadings and pretrial motions. In general, a party may raise by pretrial motion any defense, objection, or request that the court can determine, and you can finish reading that at the link here. And I'm just giving you heads up on the statutes that you'll be referencing. And then there's the Federal Rule 32, sentencing and judgment. In general, the court must impose sentence without unnecessary delay. And then you can hear at the link below. law.cornell.edu/rule/FRCMP/ by the way, /rule_32. So the 18 USC code is divided into 5 sections. Part 1 is crimes. Part 2 is criminal procedure. Part 3 is prisons and prisoners. Part 4 is correction of youthful defenders. And Part 5 is immunity of witnesses. Pre-trial detention or release orders. Under the Bail Reform Act, 18 U.S.C. Section 3142, small letter case I, a judge ordering the pre-trial detention of a defendant must issue a written detention order that includes written findings of fact and a written statement of the reasons for the detention. Again, don't you see the due process at work here? Sentencing outside the guidelines. Under the federal sentencing statute 18 U.S.C. section 3553C, lowercase, a judge must state in open court the specific reasons for imposing a particular sentence. If the sentence is outside the standard federal sentencing guidelines range, the reasons must also be stated with specificity in a written order of judgment. So here it's important to know what the guidelines say, right? The magistrate judge recommendations. When a magistrate judge issues a recommended disposition on a pretrial matter, they must enter a recommendation containing proposed findings of fact and written conclusions under Federal Rules of Criminal Procedure, Rule 59, and Federal Rules of Civil Procedure, Rule 72. So let's turn to criminal appellate procedures. A lot of questions about this one, so listen up. Denying informer pauperous status. If a district court denies a party's motion to proceed on appeal without paying court fees, informer pauperous, Federal Rules of Appeal 24A2 dictates that the court must state its reason in writing. Denying a certificate of appealability or COA. In habeas corpus proceedings, if a district judge denies a COA required for an appeal, Federal Rules of Appellate Procedure 22B1 mandates that the judge state the specific reasons why such a certificate should not issue. Release in a criminal case pending appeal. Under Federal Rules of Appeal 9A1, a district court must state in writing or orally on the record the reasons for an order granting or denying the release of a prisoner pending trial or appeal. So let's look at trial and lower courts. Remember, for state civil and criminal matters, refer to their rules of civil or criminal procedure. Remember, in bench trial judgments, following a trial without a jury, the court must specifically find the facts and state its conclusions of law separately to establish the basis of the final judgment. Contempt of court. Orders holding a party or attorney in contempt must lay out the specific facts and conduct that constituted the contempt. Due process at work. Criminal sentencing. Judges are required to explain on the record their rationale for a sentence, particularly if it falls outside the standard sentencing guidelines. Criminal sentences. Judges are required to state on the record the specific reasons for imposing a particular sentence, demonstrating that they considered the relevant statutory factors and guidelines. Denial of class certification. Orders denying class action status must be accompanied by an explanation of the legal and factual reasons why the case does not meet class certification requirements. Dispositive motions, such as a summary judgment. If a judge resolves the case or a major claim before a trial, they must outline the undisputed facts and the applicable law. Now, remember now, the judge is not determining who is right or wrong in this motion for summary judgment or the motion to dismiss. But what the judge is judging, whether the case has merit or plausibility to continue to trial. You just keep that in mind, okay? Regarding the summary judgment, when a judge dismisses a case or grants judgment before trial, they are required to outline which material facts are not genuinely in dispute and state the legal reasoning so the decision can be evaluated on appeal. Rule 56. Summary Judgment Federal Rules of Civil Procedure. And I mentioned the federal rules because the motion for summary judgment is governed by the federal rule. Now, some trial courts use their own equivalent rules of civil procedure, such as the state of Michigan, where I practice. Evidentiary rulings and contempt. Orders that significantly impact trial rights or impose punitive measures like contempt of court require a clear explanation. Injunctions and restraining orders. Under civil procedure rules, any order granting a preliminary injunction or temporary restraining order must state the reasons for its issuance and be specific in its terms. Injunctions and restraining orders. Judges must state the specific findings of fact and conclusions of law supporting why an injunction was granted or denied. When an explanation may not be needed. So let's look at some examples. Routine procedural orders, simple scheduling modifications, or routine discovery orders often do not require detailed written opinions. Denials without prejudice. A brief order indicating the motion was denied, often giving the filing party the chance to fix a technical error and refile, for example, may not require a full legal analysis. Again, that's why you want to refer to the local jurisdictional rules. And if it's allowed in your jurisdiction and you need to, ask the court to make finding of fact and conclusion of the law. Again, look at your jurisdictional rules, okay? But here are a few things that a litigant can generally ask the court to make a finding of fact and conclusion of the law. And let me reiterate, for state civil and criminal matters, refer to their rules of civil or criminal procedures, okay? Final judgments. The primary time to request findings is immediately following a final decision or judgment in a bench trial. Depending on the state, such as in Texas or California, A party usually has a strict deadline, often within 10 to 20 days after the judgment is signed, to file a written request. Prior to trial, in certain jurisdictions or family law proceedings, it is highly recommended to file a written request for findings before the trial or evidentiary hearing begins. Injunctions. A court must provide findings of fact and conclusions of law when granting or refusing an interlocutory injunction. And under the Federal Rules of Criminal Procedure, specifically in non-jury bench trials, a party is explicitly permitted to ask the court for specific findings of fact. Now, of course, this list is not exhaustive. My advice is that if you run into any one of these situations, check out the rules, okay? I trust this has been helpful. And as always, I'm Advocate Lucinda, your empowerment lawyer, and we'll see you next time. Take care.